Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases set for oral argument this morning. I am Chief Judge Anna Blackburn-Rigsby, and I'm joined this morning by Associate Judge Corrine Beckwith and Associate Judge Vijay Shankar. And we have a full house today, so we're glad to have you all here. We have a number of our law student interns who are joining us for this summer, interning with various judges. So I'm going to ask our interns to stand up for a second, not to embarrass you, but stand up. We're glad to have you and all of the interns. That's right. It's important, I think, as young law students to be in the room where it happens, to quote a famous play. So welcome. And I also want to give a shout out to a special guest, Cecily, Judge Josh Steele's daughter, is here with us today. So nice to see you. Thank you for coming to visit us. All right. And in the first case, Deja Akers versus United States, counsel for appellant is appearing remotely. Counsel, can you identify yourself for the record?
Yes, Your Honor. Russell Bykoff, B-I-K-O-F-F.
All right, good morning.
morning.
Are parties ready to proceed?
Yes.
Okay. And Mr. Bykoff?
Thank you, Your Honor. I'd like to reserve a couple minutes for rebuttal, if I may. So good morning to all of you. It's always a pleasure to see you, Chief, and to see Judge Beckwith. And for the first time, I'm meeting Judge Shankar. Just a couple of words of introduction. I'm delighted to have the opportunity to do this in a hybrid argument. I couldn't have done it any other way today. Last Tuesday, I got home from some travel, and by Friday morning, I tested positive for COVID. So I can assure you that nobody at the courthouse would want me anywhere near you today. So
we're happy you're able to do it remotely too, counsel.
I'm sure. So anyway, here and I'm in pretty good shape. I just may be reaching for my water a little more frequently than usual. And secondly, at breakfast this morning, I was delighted to see an obituary, which we could all read in the Metro section of the Washington Post, about Adele Faber, age 96, the co-author of best-selling how-to guides for parents. And this was a reminder to me that there's a lot of mystery and magic and challenge in parenting. Some of it gets discussed in criminal cases, as we're about to do this morning, but other stuff has to be learned on our own and with the help of the wonderful series of books written by Miss Faber and her co-author. So with that, I'm going to plunge into the case and say that, first of all, this is really a case of first impression. There's been no case in the district where mere words, mostly mere words, have been used to find the basis for a conviction of cruelty to a child in the second degree.
Well, counsel, there was a video that's in evidence, and I'm not sure I would characterize it solely as mere words. The video, several minutes of it depict Miss Akers verbally berating her 5-year-old child while hitting him with a lanyard and using pretty profane language. And you can hear the child crying and screaming. And so can you, I guess, getting us to the nub of it here, why doesn't that constitute maltreatment under our current statute?
It doesn't constitute maltreatment because it doesn't rise to the level that the district's law requires. And Judge Jennifer Anderson misapplied the law. She failed.
What are we missing in the law? What does the law require that wasn't satisfied in this case?
Well, it's a very good question. The law the best that we have in the district's jurisprudence. And I will add that I did several searches, first a few months ago when I wrote the brief, and then again yesterday on my legal search application program for cases around the country. And I found no helpful cases in any other U.S. jurisdiction.
But
that would
counsel,
deal with
sorry to
this.
cut
Yes,
you
sir.
off. You seem to concede in your brief that as a legal matter, verbal abuse standing alone can constitute maltreatment. Am I wrong about that? I
Verbal
know you're not
abuse-
conceding it in this case, necessarily in
Yeah.
this case, but as a legal matter, in some cases, verbal abuse standing alone can constitute maltreatment.
Yes, sir, certainly, if it meets all the other requirements of the statute and of the Alfaro case. So first, the best guidance this court has that's on the books is the Alfaro case from this court. I think it's 2004. And Alfaro in dicta discusses at length what the meaning is of maltreatment.
Why do you say
And
it's dicta? Because
why?
isn't it necessary to the court's resolution of the merger question that it's deciding?
Well, it may be, but the court, in any event, whether it's dicta or not, I think it's persuasive, and I think it's useful and it's very helpful to this court's examination of Judge Anderson's errors.
And when you
below.
refer to it as what are you talking about? Because it's not necessarily clear what Alfaro is doing with respect to the definition of maltreatment. Do you think that it is actually setting out a standard? Or it's just saying, well, one thing we know is it doesn't have to be physical.
It doesn't have to be physical. It doesn't have to be an assault producing bodily injury. It can and does include attempts to inflict pain and suffering through mental and emotional and psychological means. That's what the case stands. That's what the case says. But Alfaro is talking about extreme and egregious behavior. And Alfaro also introduces limiting language so that it would not incorporate, whether it's a mere words case or a mere words with striking with a lanyard or something else, would not incorporate a sweep up with a criminal sanction.
But
too
when you
much
say,
other behavior.
Mr. Bykoff, sorry for interrupting, when you say it talks about extreme or egregious, I agree, it uses at least the word extreme, but it also uses the word unreasonable, which sounds like not necessarily extreme. Do you see do you think the case really stands for the proposition that it has to be something more along the lines of what you think of as extreme, or what would you do with the reference to unreasonable?
Well, I would throw it in, and I was just about to mention all the other descriptions, limiting adjectives that the Alfaro court uses, which are the following: excessive, extreme, unreasonable, prolonged, serious, unjustifiable, and unnecessary.
Mr. Bickoff, can
Yes,
I
ma'am.
stop you there? You said that you're quoting the language from the Alfaro case, and I'm looking at the trial court's findings here, which seem to mirror exactly what Alfaro required. The trial court found that Ms. Akers' conduct was incredibly excessive and for no good reason. What do we do with those findings of fact as we're trying to decide whether legally her decision was sufficient?
The trial judge, and I'm going to go back to your first question, Chief, looked at the whole tape. I've seen the tape. You've probably seen the tape. I've seen
You've
it more
seen the
than
tape.
once.
Mhm.
The tape is not pleasant to watch, and I'll concede that the judge below was correct to call it not good parenting, and probably it's not something that many of us would wish to engage in ourselves or have done.
Well, she said it
But-
was incredibly excessive, and the statute and the language in Alfaro uses that same language, excessive
Yeah. I think that's a label, and I think that's hyperbole. It's an overstatement.
Yeah,
I think
but
you have,
counsel, I think the chief's, not to speak for her, but I think the chief's question is, earlier you said the trial court applied the wrong legal standard as opposed to just getting it wrong on sufficiency. And those
Yeah.
are two different points. And I think our question is, if the trial court used the language from Alfaro, which is what you are recommending as the governing legal standard, then where's the legal error as opposed to what you characterize as just a misapplication of the facts to the law?
I would clarify that and say that Judge Anderson misapplied. She misapplied the law. She misapplied the law in two ways. She misapplied it by finding maltreatment, and she misapplied it by finding an absence of parental discipline, where the government had the burden of disproving that defense beyond a reasonable doubt. So let's look at the cases, the leading cases that I cite in my brief, and the government cites as well. None of them involve verbal abuse. They all involve children in Alfaro, Newby, and Florence being struck by something. So, and this is truly a case of first impression.
Mr. Bickoff,
Yes.
the video does show Ms. Akers with a lanyard striking her 5-year-old child. And so how do we look at this as solely a verbal maltreatment case?
I think that's an excellent question, Your Honor, and I thank you for directing my attention to it. Judge Anderson put that aside, and it's in the government's brief, and in my brief and in my appendix, on the appendix, pages 4 to 5 of Judge Anderson's findings. She asked the government if it is relying on the lanyard beating strikes, and the government says no, we're not relying on that any longer.
Well,
And
so
Judge-
counsel, I
Judge-
think the government didn't rely on it for the second prong of the child cruelty statute for physical harm, but but the trial court specifically said that with respect to maltreatment, the government's relying on a combination. And then the court expressly found that the striking with the lanyard occurred. And then the court said, turning to maltreatment, the court said, first of all, you have the hitting of the child with the lanyard, and then you also have berating of the child. And so is there an argument that the trial court actually considered both aspects of this conduct? And then I have a second question, sorry to give you a compound question, but if the trial court didn't do that on a sufficiency review, is there anything that stops us from doing that?
Well, I think that the trial court did a few things that may have been a bit confusing. The trial court also said that I'm glad, government, that you are dropping the lanyard argument because it's probably covered by the parental privilege. The court says that. And the government recognizes that as well. And that's on pages 4 to 5 of the Judge Anderson's findings. Can this court rely on it? You probably can. But if the court below already excluded it, I suggest that it may not be appropriate for this court to go back and revive what's essentially a dead and discarded argument by the government, and a ground that the trial court didn't rely on. So basically, this court is focusing on the berating, and Judge Anderson mentions berating time and time again. And I agree, it sounds like a high school football coach. It sounds like a drill sergeant in the Marines or the Army or the Navy SEALs training. And this is a 5-year-old. So that's why we're here. It's not completely out of the realm of human experience. In fact, Miss Akers' language, although it sounds pretty rough, I would say falls on a spectrum that's within allowable parental discipline under the,
Can I
and
ask
it should
you a
be allowed
question?
under the criminal law. Yes, ma'am.
Mr. Bykoff, about the interaction between the maltreatment standard and the parental discipline defense, if it's a defense. Do you think that it's possible I assume you think this because otherwise, arguing parental discipline wouldn't matter, but that we could have maltreatment. We could say there's maltreatment. We find that under Alfaro or whatever, but there's still parental discipline. How can that be true when maltreatment has such, an element of reasonableness to it that also is found in the parental discipline?
Hmm.
Does that make sense?
Well, I'm gonna have to chew on that as I continue, but let me just respond initially that I think that I guess in theory you could have some kind of maltreatment, probably it's better to say you have parental, if it were done by a non-parent or by a neighbor, if it was done by a teacher, it would be maltreatment perhaps, and it would not be excused. But a parent is in a special relationship, and that's why the district has the parental privilege. Parents should receive in the law special treatment.
Right,
So,
but they would have been found to have, under your standard, done something excessive, to be found guilty of maltreatment, and yet still they could, take advantage of the parental discipline defense.
I think let's analogize it to a child, to striking a child with your hand. Is that, or putting, let's get away from the battery stuff, because that's not in this case, really, if we exclude the lanyards strikes. Let's say that the Alfaro court talks about putting a child in a dark room for a week. That's maltreatment. Would that be excused by parental discipline? Probably not. A week's a long time. Maybe these days we would say that even one day in a dark room is too much. What if you deprive the child of food, water, shelter, or clothing for a few hours or for a weekend? It could be maltreatment, and it may or may not be covered by the parental discipline. You have to look at the circumstances. What Judge Anderson failed to do was apply all the factors that this court has laid out in Alfaro and in Lee. If you look at the test, which the judge failed to do, and you apply them, we should ask, was this prolonged? No, it wasn't prolonged at all. The berating, if it was that, verbally, lasted about 2 minutes and then part of a third. Was it unjustifiable? No, it was part of parental discipline, which I'm going to come back to in talking about the privilege. Was it excessive, extreme, or serious? No, it's not like depriving a child of food or water for a day.
Well, that raises the question, how do you decide what is, these sound like fact questions, and we're all looking at the same video. And the judge is making a kind of factual determination about a lot of these things that you're mentioning. How do we defer to those, or do we not have to defer to them at all? She also, heard testimony from a lot of witnesses that might, whose testimony might kind of blend in with what she sees in the video.
Right. I wouldn't defer. You have the video. You have the same video the judge saw. We have the testimony. We have the testimony that Miss Akers normally spoke to her friends and her paramour, the father of this child, with profanities. It was her style, whether for good or for ill. I think you're free to make your own determination de novo on the sufficiency argument. And finally,
We're free
let
to
me
make
say,
our own factual determinations.
you're free to set aside the judge's factual determinations if they're without any basis in the evidence. She really didn't make factual determinations that were pure factual determinations. She applied legal labels. She made conclusory determinations, and with those, you're not bound. Those are legal questions. And finally, if I may just address, I suspect my time's getting near the end.
Your
But-
time is up, but it'll let you finish your argument and you reserve some time for rebuttal as well.
Thank you very much, Your Honor. I've had to answer a lot of questions, which has been my pleasure. The parental privilege then also has a number of factors that Judge Anderson completely ignored and didn't apply. If you look at the Lee case, which we cite which are cited in both briefs, you look at the child's age, health, mental and emotional development, alleged misconduct on this and earlier occasions, the kind of punishment used, the nature and location of the injuries inflicted, any other relevant evidence. The child was 5 in good health and sound mental and emotional development. His conduct at school, which was the predicate for the mother's chastisement, was pretty severe. It seems to have been repetitive. It happened again and again. The mother was clearly at her wit's end. She wasn't getting any help from the child's father. She was all alone. The teachers were calling her, pulling her out of work to come pick up the child. He was doing some terrible things at school, and the mother clearly had to get him to, and if you listen to the tape, her focus is entirely on the child's behavior at school. It doesn't go beyond that. So she's clearly focusing on a corrective purpose, which is the definition of the parental disciplinary privilege. And she doesn't, anyway, oh yes, and then I would characterize her chastisement as not unreasonable. The government has to show beyond a reasonable doubt that either it was not with a corrective purpose or it was not reasonable. And I submit that the government failed to do that, and this court should reverse this conviction. It's an unsupported, unfair conviction. Please relieve Ms. Akers of the taint of a criminal conviction and the collateral consequences that are flowing from it. And I'll stop with that and then come back for rebuttal if I may.
All right, thank you, Mr. Bikoff.
Thank you.
Mr. Rubin?
Your Honor, Ari B. Rubin for the United States of America. And if it may please the court, on this sufficiency of the evidence review, this court must affirm unless the government produced no evidence upon which a reasonable fact finder could infer guilt beyond a reasonable doubt. Here, the government believes the only question left squarely before the court is whether the defendant's conduct in the form of discipline was reasonable.
Well, I guess before we get to that, on the maltreatment prong, is the government's argument that the trial judge relied solely on the verbal beratement, use of profanity, yelling at the child, or is it the government's position that the lashes with the lanyard on the child's legs and other parts were a part of this as well?
So the government does acknowledge that it was operating solely on a maltreatment theory of the maltreatment prong. But what the government believes is that there was a litany of facts before the court, which the judge commented upon, and which became the facts that she ruled upon. And those included 6 minutes nearly of berating, cursing, screaming language, all while the child was crying, cowering, literally.
Well, the video that we all watched is actually about 13 minutes long. And the first few minutes of it include just what you described. But the bulk of the remaining part of it includes a pretty calm discussion between the mother and the child's father, who was there and who actually videoed this on the telephone, calmly talking about the child's disciplinary issues at school, the fact that she was at her wit's end and concerned that the child wasn't understanding the consequences of his behavior, which was escalating apparently at school, taking the property of other students, resulting in this latest behavioral issue where the child apparently pulled down his pants and told students and maybe even the teachers to kiss his bottom. And the mother is very concerned that he's not understanding the other disciplinary steps that have been taken up to that point. What do we make of all of that when we're looking at the reasonableness or unreasonableness of what she did here?
The government would say two things in that regard, Your Honor. First of all, there's no question at this point that as one of her motivations, the defendant intended to discipline her child for the reason she listed there, in which other witnesses have discussed, including Avery, the child's father. But what that also shows is that the defendant had more than one mode in interacting with people. She was able to contain her anger. She was able to contain her frustration. And what you saw in her actions against the child and in her explanation of the actions against the child was a desire to vent, to expose that frustration, to change the child.
No, I'm not so sure the venting piece. I mean, she says very specifically that she sees herself anyway as disciplining him, showing him the consequences of his actions, that she's tried other things up to that point that haven't worked to get him to understand that he can't behave like that.
What she also says is that her very goal is severe mental damage. She expressly states that she wants to have a mental impact. She says it more than once.
Can I
And-
ask you about that? Because
Mhm.
the government does make a big thing of that, and so does the trial court.
It was the judge's finding.
Right, exactly. And so it's hard, it's hard to know what to make of it. Like, I didn't see it the way the judge did. And then again, this comes down to the question is the way I hear it invalid because this is kind of factual. And the judge also kind of treats it like a credibility determination. And I don't, can a judge make a credibility determination based on what someone is saying in a video?
I'm not sure, Your Honor, the government reads it as a credibility determination, but certainly it's a fact-finding question of what was said and whether the conduct was.
Well, she
was
decided
reasonable.
what she intended. I guess, maybe she's, yeah.
It would be an inference, Your Honor, and
Yeah.
all inferences in this case must be held in favor of affirming the verdict.
Counsel, you started to give a very long answer to the chief's question about whether the trial court relied on the hitting as well as the verbal abuse. Can I get a short answer to that?
Sure, I'm sorry, I never had a chance to respond. Yes is the short answer. That the government is not arguing that the hitting alone would have been sufficient. But what it is arguing is that there was a tapestry of actions that all happened in a very tight span, including the 4 or 5 strikes with the lanyard while the father, Avery, was
Right,
counseling
but
that
I
this was
know that
enough.
that's in the evidence. Is your argument that we can therefore consider it, or is your argument that the trial court did consider it?
Our argument is that the trial court looked at it as one of the factors that furthered the indication of extreme emotional harm. It is part of the maltreatment prong. It is not part of the physical. We're not looking at this as a physical abuse issue.
And then can I ask a follow-up question, which is if we were to conclude that the trial court didn't rely on it, is it your position that we could still rely on it on a sufficiency review?
There's no question that this court could still rely on that. It would be at a different standard perhaps. But again, the government believes that the judge did factor it into her decision. It was commented upon.
So on the maltreatment prong that the government is relying on, doesn't this case go further if you're not relying on the physical strikes with the lanyard specifically, you're focused on the maltreatment prong. Does this case go beyond what our prior case law holds with respect to maltreatment? Would this be sort of expanding
So
how the court views maltreatment of children?
it wouldn't no, it would not be expanding, Your Honor. What it would involve is looking at potentially the boundaries of it. We believe that
Say
Bradley
that one more time. It wouldn't expand it, but it looks at
establishing
the
what the
boundaries.
boundaries are. They haven't been established yet because the cases that have commented upon this, Alfaro being, the primary one, Bradley, what they did was establish the existence of a merely mental prong for maltreatment. And it set some general criteria, unnecessary or unreasonable mental pain, I believe, sufficiently extreme or unreasonable. Again, it can be just unreasonable, unjustifiable. These are the things that Alfaro did. And the judge considered those aspects of the law and looked at the facts in this case and found that the duration, the fact that it was repeating. Let me point out just two factors, if I may, because I haven't had a chance to acknowledge them yet, which is that this was not the first instance in which she had expressed her discipline in this way, involving both physical conduct and extreme language. This was a pattern of hers, which the father commented upon. Number two, which was a very big factor for both the judge and the government, the threat of repetition that happened at the end. And we look at all of these factors, that she would do it again in the morning. She said that multiple times. And the government looks at all of these factors together. And the reason why I said at the very beginning that the only thing that is left is determining whether this is reasonable as a form of discipline is because if a stranger did this to a child, there would be no question that it would be unreasonable cruelty, that you couldn't just walk up to a child on the street and berate them and treat them in this
So
way.
counsel, are you agreeing then with your colleague that Alfaro provides the legal standard here, or are you, I'm a little confused. Are you saying that this court in this case has to define the legal standard going forward?
We are saying that Alfaro established maltreatment based on a emotional or mental prong as a distinct crime from the physical.
Right. I think everyone agrees with that. So then what is as Judge Beckwith asked earlier, there are a lot of adjectives used in Alfaro. You seem to be pointing to unreasonable, which obviously is the best one for the government's position here, but is that the one that governs?
So a close reading of Alfaro, we believe, shows that in almost every instance when an adjective is used, it's used in the disjunctive, where unreasonable appears multiple times. And unreasonable seems to be the big aspect that this crime can be predicated on.
What can I ask about the rest of the video? The first part of the video shows the mother yelling, cursing, in what she calls disciplining the child. But there's a piece of the video that was interesting to me, that the father is there throughout this discipline and is actually secretly videoing it on his phone. And there's a point, he doesn't intervene, he doesn't stop the discipline, he doesn't say anything about it. He films it on his cell phone. There's a point during the video where he says he's already disciplined him. He's already had a long talk and whipped him.
Yes, Your Honor.
How does that factor into this at all? Why are we focusing only on, for this purpose, only on the mothers?
We believe it factors in a significant way to the extent that it stands as a contrast with what the mother's conduct was. That Avery, the father, on multiple points in this video explains you can pop the child once or twice. You can express your feelings in a contained way, but doing it in the sustained manner, doing it where there seems to be no out for the child on the other side, that becomes unreasonable. So what that does is it gives the defendant in real time a point of contrast for why she is being unreasonable, and yet she persists in all of this. Another point of contrast, which I think this court can look at in seeing why it was unreasonable in this March 9th incident, was that there was also a March 14th incident, which is not at issue in this appeal because the judge found the defendant not guilty on that incident. But that incident involved almost entirely physical activity. It was still a mental anguish theory, but it was physical activity in which, as it was later explained by the defendant, she really did want to be like a drill sergeant.
Do we have that video? Do you know?
It wasn't a video, Your Honor. It was just an audio recording.
Oh, an audio. Do we have
I'm not
that?
sure it was ever
Okay.
put up in the record
Okay.
before this court. But again, it's not at issue here. What it merely establishes, and certainly the judge's findings on it are before this court, which is that it was bad parenting. It involved, you know, a lot of sort of inappropriate statements, but it was not at this level, which had the physical aspect, which had the repeated aspect, which had the boy cowering in his underwear, which the government believes is also significant, the lack of just pure protection that the child has around him. And again, the concern here with why it's significant that this is a parent is that the parent is supposed to represent a safe place for the child. A child knows that they can't trust a stranger. That's
But
why.
counsel, we have family law, child abuse and neglect statutes in this jurisdiction. And what we're talking about here is criminal liability, right? And so am I right? Now, I don't want to, you know, boil down your position, but you can correct me if I'm wrong. Is it your position that unreasonable parenting, that's the word from Alfaro, can give rise to criminal liability?
Unreasonable discipline, Your Honor. That would be what's at issue here. Her conduct, which she tried to defend on the parental discipline privilege, was unreasonable. It crossed a line.
Right.
If there are no further questions, the government would ask to affirm the decision below.
All right, thank you.
Thank you.
Mr. Bickoff, you reserved a few minutes for a rebuttal.
Thank you, Your Honor. If the standard is unreasonable, and we're going to punish parents for being unreasonable in their discipline of their children, then this court is headed down a very dangerous path. The government is setting before you and trying to pull you, as Judge Anderson allowed herself to be pulled in a direction that is not good for parenting, and it's not good for the criminal law. Mr. Rubin said basically that the government's asking you to start with Alfaro and then expand the boundaries in response to your question, Chief, expand the boundaries of maltreatment. And as you open up maltreatment and open up and the standards only reasonableness, then parents all over the district are going to be at risk of being hauled into court if a partner who's involved in a custody battle surreptitiously makes a video and turns it over to the prosecutors or the police. I don't think that's the way.
Mr.
we
Bickoff,
want to go.
you just touched on a question I forgot to ask you earlier. Is there an ongoing open neglect, child neglect case or a case in family court involving the parents and the child here?
That's a difficult question for me to answer, Your Honor. I've never been able to get family court records online. I think I'd have, and I didn't try to get a judge's permission to unseal these records. I'm
You
aware
just
that
referenced a custody case, and I wanted to pin you
Yes.
down on the source of that reference.
okay, the source is my client and the record in this case. There was a custody case that was in process in family court at the time of this incident, which was about 15 months ago. So March 2022, was it? 23, March 2023, last year. The custody case, as I understand from my client, is still continuing. She's at risk of losing legal and physical custody because of this conviction. And my appeal is to give the parents, in this case, and parents in general, as Ms. Faber said, and the author of the books series, whose obituary appears in today's paper, parents ought to be allowed to make some mistakes. They ought to be, and children make mistakes too, and they learn. Parents as well learn from mistakes. So this conduct may have been unreasonable, it may have been something that you or I wouldn't engage in, but it was not the kind of egregious, extreme conduct envisioned by the statute or the case law, and shouldn't be punished criminally. That's
Can
our
I ask
position.
you just one more question about sort of the intersection between parental discipline and this, verbal maltreatment? I take it parental discipline, the defense is like a common law thing. And as I understand it, the jury instructions refer to force, physical force. And I think the cases also do. Is there, how do we have a parental discipline defense in a case like this? I mean, I guess one answer might be it's not purely verbal maltreatment, as I think the government would say. But is it just that those cases about parental discipline haven't evolved enough to take into account cases like this?
I understand your predicament, Your Honor. The law is undeveloped. Most of the cases that come through Superior Court and that end up in your court and in the past decades have involved physical abuse. They've involved the other prong of the child cruelty statute. They have not involved maltreatment. They have not involved mostly, if not entirely, verbal conduct. And they have not involved what Alfaro calls the infliction of psychological or mental pain and suffering. It's all been about physical stuff. So there's a dearth of case law. You're operating largely, I should say, are operating to a sad extent in a vacuum. And I noticed that, Your Honor, the element 2 of the parental discipline defense is whether a parent used a reasonable and necessary amount of force in the discipline. And in this case, of course, if you disregard the hitting with the lanyard, she used no force or violence at all. It was merely verbal conduct. So the issue is, did the tone and the content of her words amount to some kind of force? And is verbal force, tone or content, different from physical force? I think it is. You may have to expand how you look at the application of the parental privilege.
All right. Thank you, Mr. Bickoff. Thank you, counsel.
Thank you, Your Honor.
Mr. Rubin, for your briefs and arguments today, and we'll take the case under advisement.
Thank you very much. I'm going to sign off.
All right. Okay, thank you. Our second case this morning is Friends of the Field versus DC Board of Zoning Adjustment. All right, before we begin, counsel for the respondent, are you going to be dividing up your argument?
We are not, the district is not going to argue, so we'll, on behalf of Murray, the full 15 minutes.
All right, thank you. All right, and Mr. Axelrod, are you ready to proceed?
Yes, Your Honor.
All right,
I would like to reserve a few minutes for rebuttal also.
all right, thank you.
May it please the court. This case requires the court to decide whether the plans submitted by Murray School are consistent with the regulations of the Board of Zoning Adjudication, or whether the regulations should be twisted to allow Murray to do what the regulations clearly don't allow. And the key portion of the regulation is the provision that defines accessory use. It says accessory play and athletic areas, dormitories, cafeterias.
But counsel, can you explain why we get there as opposed to stopping with K1?
This is part of K1.
Well, accessory use is in K2, right? Accessory play in athletic areas, that's in K2.
Yes,
And so K1, is it your position that no educational use involving physical education can take place on a separate campus? Or in other words, outside of the locational aspect of accessory
yes,
use?
because the locational aspect is clear in K2, and it's also clear in section 100.2, which says that the incidental and subordinate uses are located on the same lot.
Right, but that's if you already assume that the use is accessory use or incidental use. And I guess my question is, can principal physical education use be located separate from the main facility?
We believe not, and we believe not because when the regulations talk about what an accessory use is, it's clearly including some kind of sports.
Well, but before you get to that, Counselor, when the regulations talk about principal educational use, don't we have to look at that? And Murray in their mission, when they describe the philosophy behind their educational philosophy, physical education is an integral part of that. Why? And we have, a lot of jurisprudence nationally, across the country, which seems to affirm that education and physical education is a principal part of a wholesome education for children K through 12 or beyond. Why can't we stop the analysis there? Why do we then have to get to accessory use when they view physical education as an integral part of their principal educational mission?
I don't believe that the district, well, let me start this way. The District of Columbia requires a certain amount of physical education as part of at least part of the high school and middle school career. We don't believe that physical education is the equivalent of math. There's an educational component in math, there's an educational component even in physical education, but there's not an educational component in competitive interscholastic sports, which is what Murray needs this facility for.
But is the opposite view unreasonable?
It is when you look at part 2 of the regulation. The people who drafted this regulation clearly thought that sports was incidental and subordinate to the educational component. And it's the regulation that controls, not whether the regulation can or should be ignored. It's what the drafters of the regulation thought.
Well, Murray specifically says that their integrative educational philosophy values physical education as a key component, not an accessory use component.
I think every school would say that.
Well, not,
and that's where
they don't all say it in the way that Murray does in its mission that might bring it within the purview of many cases throughout the decades, showing that physical education is integral to a child's education.
There aren't many cases involving the BZA regulations. And this court has never held, and this court in fact has refused to hold, that physical education as a principal use is separate from the accessory use. And I would remind you that in the National Cathedral case, the BZA tried to say it was both. It was an accessory use and a principal use. And this court said, where it's an accessory use, we don't have to decide anything about principal use. So this is a case of first impression. And we believe that you can't ignore the part of the regulations that say accessory play in athletic areas, dormitories, cafeterias, recreational or sports. If I had to guess, I would say if we focus on the word cafeteria, the BZA's regulations would allow Murray to put the cafeteria on the ECC lot and bus people to the cafeteria for lunch, bus them back to go back to class. I'm sure that Murray would say lunch is a fundamental part of the class of the school day, and it is.
But
And in fact, the DC regulations defining what happens in a school day include lunch too.
But counsel, even if we get to K2, which I'm not sure we do, but and even if we assume that accessory modifies all of the nouns that follow it, which I'm not sure it does, but the first part of K2 says above uses, meaning principal uses for education, may include but are not limited to. And so you can have an accessory sports facility, and let's assume this one is, but in other words, you can have, I guess what I'm saying is you could have a non-accessory sports facility that still falls under K1 because K2 doesn't limit K1. It says that principal educational uses can include, but need not necessarily include accessory sports facilities.
I disagree with your interpretation of may include. We read that to say it may include other things. If they wanted to build a building for faculty offices, that's not one of these listed. So there may be other accessory uses, but they are saying that sports is an accessory use. And whether sports is an accessory use because it's play or athletic areas or sports facilities regulation, however you define sports, it's an accessory use.
And so earlier you focused on interscholastic.
Yes.
And I assume you maybe mean outside of school hours, but maybe not. I mean, would you agree that, or what would be your position on a sports facility that is away from the school that is used for daytime PE that is a part of the school's curriculum?
We would say that can't be an accessory because it's not on the same lot. We can quibble about what lot means. There are BZA cases saying 140 feet away. There's a BZA case saying it's across the street, but there's no BZA case saying 4 miles is okay. You can ship students 4 miles for their physical education. What I meant by interscholastic activity is competition with other schools. That's very different from saying we're teaching teamwork wherever we're doing it. If we're teaching teamwork at the Murray facility, at the Murray school, they're teaching teamwork. They're teaching some sports skills. That's what the law requires. It doesn't require competitive athletics with other schools. I almost hate to say this, but if you look at the NCAA and what's happened to what used to be the definition of student athlete, it's almost gone. At the high school level, these kids are students first. They're athletes second, and that's what the regulations suggest as incidental and subordinate.
Well, but I don't think the zoning regulations can specify what educational needs and priorities are for a school like Murray or other schools. And Murray seems to take a different view that student athletes and physical education, it's a requirement for all their students to graduate, whether they're on a competitive team or playing another sport or doing a different kind of physical education. So I just don't think the zoning regulations go as far as you contend they do with respect to regulating educational goals and outcomes for students.
K1 specifically says that it has to provide district or state mandated basic education or educational uses. So the zoning regulation incorporates some definition of educational use, and that educational use can be limited to what the District of Columbia defined as an educational use. we've cited the regulation that the District of Columbia requires 1.5 units of sports, of recreation. It doesn't require what Murray says is part of its program.
Well, Murray's requirements are not inconsistent with the DC educational requirements. They may go beyond that. They may include other things, but that doesn't mean that they're inconsistent in saying that part of their principal educational goals are integrating physical education with their other subjects.
We believe that you can't reconcile section 1 and section 2 with what Murray says is part of its educational program. And we're not saying Murray can't have its educational program defined however it wants to define its educational program. What we're saying is the zoning regulations control where that happens. And it's the where that's at issue in this case, not the what.
All right. Did you want to reserve the remainder of
Yes,
your
Your Honor.
time for rebuttal? Thank you,
Thank
Mr.
you.
Axel. Counsel. Yes, Mr. Ronan?
Yes, Your Honor. Good morning and may it please the court. I am Gary Ronan and I represent the Murray School. Let me explain why this use is allowed physical education use and why their argument is wrong about K2. So K1 provides a definition for physical education, and it says it can be an educational, academic, or institutional use. So it does not have to be strictly academic. The primary mission of the school has to be to provide academic and educational instruction, but that of course is the mission of the Murray School. The reason why K2 doesn't say that a school sports facility has to be in all places and all events and accessory use is look at the language. It's not, as you said, Judge Schenker, it's not limiting. It is K2 says the above uses, referring back to K1, include. It's expansive or explaining, illustrating what is included in a principal private education use. If the drafters of the zoning regulations wanted to provide that a school sports facility could only be an accessory use, they could have said that in clear language. And that's simply not what this language does grammatically or logically. The other thing that is, I think, really important on this issue is the notion that this particular type of use could only be an accessory use is inconsistent with basic zoning principles and with the definitions of principal use and accessory use in the zoning regulations. So a principal use is defined to be the primary purpose or activity for which a lot is used. And an accessory use is another use that's on that same lot that is customarily incidental to and subordinate to the principal use. So in order to determine whether a use is principal or accessory under those definitions, you have to look at what the primary purpose or activity of the lot is. That's what tells you whether a use is principal or accessory, not the type of use it is. And so this notion that there can be a use that can only be an accessory use is just inconsistent with those basic zoning principles.
Well,
and
I'm a little
definitions.
confused about that, or at least by the limits of your argument. So if this field offsite is leased by the Murray School for and I know Murray has a football team, sent a player to the Steelers, I know that much. But only had nighttime football games with paid concession to attend, and didn't have physical education there. I mean, maybe that's physical education, maybe that's your argument, but I mean, would that be principal use, principal educational use, or accessory use?
Well, so every lot has to have a principal use. And that's what the definition of principal use is the primary purpose or use. Let me be precise. The primary purpose or activity for which a lot, structure, or building is occupied. That's the definition of principal use. So if you want to know what a principal use of a lot is, you have to look at what's going on there, right? So in that case, I think the way you've described it, that would be private educational use. If it's part of the school's, if it is part of the school's curriculum, as is the case in Murray, as the Chief Judge has pointed out, to provide physical education, and that's a requirement for graduation. that would be part of the school's principal, that's a principal private educational use. Think about it this way, it doesn't really, it should not matter in terms of what the use of that field is, if it's a sports field or stadium, whatever it is, whether it's on the same lot as the academic buildings or it's on a separate lot. It's still the same use. It's still educational use. And of course, as you pointed out, Chief Judge, in the questioning before, we have a century of jurisprudence in this country, including going back to this court's decision in the 1927 Shannon Luke's case that recognizes that physical education and school sports are a central part of what our schools do.
Well, in this case, could the requested use that Murray seeks for the field be both principal and accessory? Or if we focus on the K2 accessory use, does that mean Murray would be precluded from putting the field there?
I think, again, the way you have to think about principal use is you look at the lot and say, what's the primary purpose or activity here? That's what tells you if it's a principal use. Maybe I can answer your question this way. If this field were on a lot where there were academic buildings as well, you might consider it to be an accessory use. And that's kind of what happened in the National Cathedral case, right? The court said, well, that's clearly this is this sports field is at the very least is accessory to the school's academic instruction there.
Are there some factual distinctions between what we have here and what happened in the National Cathedral case?
Yes, in that case, the sports field was on the same lot as the academic building. So that's why it was appropriate for the court to consider it to be an accessory use, at least in that instance. And the court said, well, we're not going to decide the issue of whether it can be a principal use as well. But every lot has to have a principal use. So if you look at this lot, you say, well, what is the principal use? The BZA reasonably determined that it falls within the private education definition. And part of the reason why that makes sense is what else could it be? I mean, this isn't a professional sports stadium.
Well, I guess
People
that leads to the question I was about to ask, which is, can you give me an example of this lot being offsite, leased by Murray, that would, the principal use of which would not be educational? Or is it your position that simply because of the fact that it's being leased by Murray makes its principal use educational?
Yeah, no, it's not the fact that Murray is leasing it or using it. It's the use that's being made of that lot, right? So if Murray leased it and they built a Taco Bell, that would not be educational use, right? That's a restaurant.
What about if Murray leased it and then subleased it, as Murray intends to do, to other groups for athletic activities that may not be affiliated with Murray? Does that make it not a principal education? Does that make the principal use not education?
It does not. And the reason is, and just one point of clarification, Murray's not going to sublease. It's just going to allow other schools and youth athletic groups to use the field. But the reason why it's still.
Is that an educational purpose, the use by other groups for athletic activities?
Yeah, so if you look at the application in Murray's application here and also the MOU with the ANC, it describes that they're not just going to be allowing anybody to use it. They're going to, the allowed uses are going to be limited to other schools for their school sports and physical education and youth sports organizations. So what I think the right way to think about it is, and also importantly, Murray committed in the MOU that it's the time of its use will be larger than the time of all those other uses. So the primary.
I'm sorry, when you say allow, sorry for the interruption, but just so I understand, is it now off the table that they'll be getting paid for this?
No, they'll be paid.
Mhm.
And that's customary. So this is the way to think about this issue, I think.
Customary for educational purposes or customary?
Cus-
For
it's-
what?
Yes, it's customary for schools with athletic fields and facilities to allow other school students, other athletic teams, youth sports organizations to use those. Because no school needs to use the field 24 hours a day, 7 days a week, right? And so there's a significant public benefit to allowing other schools to use the field and the facilities and to allow other youth sports organizations to do that. And maybe this is your question, it's customary to charge a fee for that because if there's wear and tear on the field. I mean, that's what it is. This isn't a moneymaker for Murray. There's certainly nothing in the record that establishes that, and it's just not true. You charge a fee so that you can, do the maintenance you need to do on the field.
What percentage of the use of this field has to be for educational purposes? Is it all of it has to be to further Murray's educational mission? Substantial part of it, any portion of it? How do you view that?
The way I view it in terms of how it intersects with the question of what the principal use is that I think it has to be more than 50% is the way I think about it, because it has to be the primary or principal use of the property, of the lot. And that's clearly the case here, right? This isn't being used with one exception. This is being used for school sports and youth sports. The one exception is there's a few hours a week where it's going to be opened up for the neighborhood. So people can come walk around the field, play soccer with their kids, things like that.
Can I ask you about some of the other concerns raised by the, we have two zoning cases today, so forgive me, the Friends of the Field community members about the retaining wall, the height of it, the fact that it may obscure some views of what was enjoyed as an open green space and field, and also the replacement or use of artificial turf, which has some, according to the citizens group, potential environmental concerns.
Yes. So starting with the retaining walls. The retaining walls are being constructed as of right under zoning. So Murray did not need any zoning relief for the retaining walls. There are going to be 4-foot segments. And then I think it's 6 foot or so, maybe 8 in between each segment, and then it goes up again. That's what's required by the zoning regulations. The walls are also going to be constructed so that there's a nice stone facing on them. And there are going to be numerous plantings on the walls. And you can see this in the professionally prepared illustrations that are submitted with our application. So when you look at those, you can see that they present very nicely and well. And the BZA reasonably determined that those walls constructed as they are and are shown in the application and plans do not create objectionable conditions, which is the standard.
When you say they're graded up incrementally, I may have misread this, but in part of the briefing by petitioners here, there was an indication that it could create as much as a 12-foot high obstruction of views of the field.
Yeah, if you look at, let me get you the citation here.
That's description sounds different than the depictions.
Yes.
But it must be based on something. So I guess I want to hear what your
Yeah.
response is. It sounds like if you're higher up on the grade, that the retaining wall does create a higher height obstruction, but I could be misinterpreting that.
Yeah, so well, let me say this. What's happening here is, the current field is sloped like this. And in order to have an athletic field, you need to flatten it down. So they're going to flatten it out, move some of the earth from here to over here, and then you build this retaining wall like steps over here. So the thing that's inaccurate about the description that was in the other side's brief is it's not going to be a 12-foot wall, big stone wall that just goes up like this. If you look at the joint appendix pages 129 to 151, 129 to 151, you'll see these very nice professional illustrations, that look like real life, that show you how this is going to look.
Now, I've seen those and I've also read the description and they seem inconsistent. So that's what I was asking you to comment on.
The description in the other side's brief is inaccurate in a couple of respects. One, it's not going to be one 12-foot wall. Two, it's not within, I can't remember the number of feet, but it's not within 10 feet of the house next door because there are setbacks. And then you also asked about the turf. So let me address the turf. If you read the BZA's decision, you'll see that it did what it's supposed to do. It considered the benefits and drawbacks of each natural grass and artificial turf. And it decided, based upon all of that information, that artificial turf is the better and right solution for this field. it talks about, the BZA talks about in its decision, the fact that there are problems with natural grass. Number one is it wears down, and because of the wear and tear, you can't use it as much. So here, what that would mean is if Murray had to use natural grass, it wouldn't be able to allow other schools and the community to use the field, perhaps at all, but certainly not nearly to the extent that it can now. You also with natural grass have problems with compaction. The ground gets compacted, which causes water runoff problems. And you have problems with fertilization. You have negative environmental impacts that come with fertilization. So the use of the artificial turf solves all those things.
But did the board address that? I mean, I know it addressed the downside of having natural grass, but did it address the downsides of having turf, including the PFAS issue?
Yeah, so so the answer to that question is it specifically addresses, it talks about those downsides, and it says on balance, we think natural grass, or excuse me, artificial turf is the right and better solution here. There's a specific finding in the board's decision that the use of turf will not create objectionable conditions. And there's also a specific finding in the board's decision that more broadly, this project will not create adverse environmental impacts. So both of those things go to the use of the PFAS or the presence of PFAS in the turf. It is true that the decision does not specifically talk about PFAS. And there's a good reason for that. And that is if you look at our record in this case, which is 1,150 pages more or less long, there are fewer than 10 pages where PFAS is discussed. It simply was not. They've made it a major issue in their appeal. It was not a major issue before the BZA. And if you look at the hearing transcript of what the BZA heard, you'll see there are two witnesses who are Miss Conway and Miss, I had this in my head. Well,
Bennett,
there are two witnesses, and one of them says, Bennett, thank you. So Miss Bennett testified, and by the way, each of those two witnesses testified for only 2 pages on the transcript about PFAS. Miss Bennett concedes in her testimony that PFAS is not even regulated by the EPA, meaning it's perfectly legal surfacing material. That's not only not outlawed by EPA, but it's not even regulated by EPA. And Ms. Conway concedes in her testimony that the science about whether PFAS causes cancer, and these are her words, is extremely incomplete. So that's the evidence.
What about the aesthetics? I guess was it the board's view that tearing up all the natural grass and replacing it with astroturf or artificial turf, and then adding a few plantings on the perimeter, balance that out?
You're talking, I want to make sure I understand your question. Are you concerned about the negative impacts of losing natural grass where it exists?
Yes, and we had an open green field in a neighborhood that appreciated that. And now there's an astroturf field with a stone wall around it and a few plantings. Was that discussed, I guess, and weighed by the BZA, the board?
Yeah, I mean, I think it was insofar as the board describes all of this in the decision and decides that the configuration that is being proposed does not create objectionable conditions. I want to be clear about this, though, in terms of what the site is going to look like. This is a larger lot than just where the field is going to go. So you're still going to have extensive grassed areas. They're preserving many of the heritage trees. They're planting additional trees and shrubs and bushes. It's not just a few, it's a lot, which you'll see in the plans. So a lot of that is still being preserved. And the other thing I think is maybe significant to your question is the current field is not in great shape. It's not a beautiful grassy meadow. It's a lot of dirt.
Any other questions? All right, thank you.
Thank you.
Council, Mr. Axelrod?
Yes, Your Honor. I'd like to address a few things that were said. First, with regard to the retaining wall, it's undisputed that the slope of the field is now 35 feet high on one end to the low part at the other end. It's undisputed that they want to raise the low end by 12 feet to have a level field so they can play their sports. It may take 3 4-foot fences or 4-foot walls to do that, but it's going to be a 12-foot wall. The houses at the low end on the 28th Street side and on the Nebraska Avenue side, which used to be looking out at the low end of the field, will now be looking out at a 12-foot wall. And it may be 3-4 foot segments, but it's going to be a 12-foot wall.
So
That's
when
the-
you say I guess that was the part that was a little confusing to me, that there's no, on the lower end or the lowest end, there's not one 12-foot height vertical span.
There will be. It'll be a 12-foot span with 3 components, maybe.
Well, I think we're saying two different things. The drawings seem to depict an incline that may gradually increase as it goes up, but each segment of the wall seems to only be 4 feet high.
And that's where we have the Economides and Caribe case that this court decided and that we briefed. That was a wall 300 feet away that blocked the view. We're going to have, whether it's 3 segments of 4 or 1 segment of 12, there's going to be a 12-foot height across the bottom of the field, completely blocking the views outside of those houses.
But counsel, do we even get to that if, under the objectionable aspect of the zoning laws, regulations versus the fact that the zoning, the retaining walls are zoned as a matter of right, are permissible as a matter of right under the zoning and
Certain
regulations?
things that are permissible as a matter of right, as in the Economides case, are not permissible because of what they do to other locations. And that's, and basically, there's nothing in the BZA decision that indicates they looked at the Economides case at all, and they should have. With regard to artificial turf, one thing is absolutely clear, and that is the science concerning PFAS has exploded since the BZA hearings. We have the Office of the Attorney General now suing PFAS manufacturers. We have the District of Columbia passing a regulation within the past month or saying that there shouldn't be artificial turf on the Lafayette Field, which is maybe a half a mile from the ECC field. Things are changing rapidly, and the BZA should at least consider that in determining what is acceptable to thrust into a middle-class neighborhood. The other thing I'd like to say is that it's clear that Array will be charging a fee to the other users of this field. The BZA order and the MOU, but the BZA order lists what hours Murray can use the field and what hours Murray can lease the field. And there's also hours that Murray is essentially giving away the field to the ECC and the public schools. But those hours are from 9 to 3 or 9 to 2, depending on the day of the week, when Murray could not use it anyway. That's the difference between a plot that's on the school's grounds and a plot that's 4 miles away. It becomes useless to Murray from 9 o'clock in the morning to 2 or 3 o'clock in the afternoon, because those kids are in school then. And the DCPS students are also in school then. They're not going to be shipped to the ECC lot to have some physical education and then go back to school. It's the transportation that's required that makes this a difficult case. Now, I would say, and we can't, I guess, ignore the fact that every lot has to have a purpose. But I think the lot's purpose can be the accessory purpose. It doesn't have to be a principal purpose. And it's our contention that the regulations say that lots have accessory purposes, and there are conditions for what constitutes an accessory purpose that isn't met here. So if you have nothing further on, thank you.
Thank you. We'd like to thank both counsel for your briefs and arguments, and the case is taken under advisement. Thank you. We have one final case remaining this morning. West End Citizens Association versus DC Zoning Commission. Good morning, council. Are you ready to proceed?
Good morning, Your Honor, and may it please the court. I'm David Brown for WECA, the West End Citizens Association, and I'd like to reserve about 3 minutes for rebuttal.
All right, thank you.
I hope that this device is working. It's very helpful to me because I'm a little hard of hearing these days.
Well, I'm glad, and if at any point you feel it's not working properly, just let us know. We can make sure you get a operating one.
I think I'm good for now.
Right.
Your Honor, WECA was a party in strong support of the PUD proposal to build a large new building between I Street and Pennsylvania Avenue in 2018. And they were particularly supportive of the plan to put 30,000 square feet of neighborhood serving retail into the project. But they were quite surprised in 2023 when GW came back for a modification to change some signage and doorway to facilitate the installation of a bookstore, campus bookstore, for over half of that 30,000 square feet. This was completely new news to WECA because they thought that neighborhood serving retail meant there was going to be additional retail in an area that needs retail rather than
Can I
a relocation
interject there?
of the campus store.
I'm sorry, I wanted to interject there because a large part of the petitioner's argument focuses on what they thought the parameters of the initial plan unit development was. I guess based on the 2007 public hearings and the 2018 public hearings. And I was hoping that you could sort of narrow and focus us in on what language in the original plan unit development lead WECA to conclude that the bookstore wasn't an authorized use there, relocating the bookstore.
Your Honor, all I can say about that, I was not a party to that proceeding and it was handled without counsel as far as I can recall, because WECA and GW have had a long and productive relationship that's not an arm's length relationship. They're not adversaries, they're not partners, they are cooperators. And by and large, they've accomplished things through consensus rather than litigation. And I have to say that my client was basically led to believe that when neighborhood serving retail was going to be included, they did not get into this question about the possibility of there being a relocation of the campus bookstore at that point. It was just not in the cards as far as they thought.
Well, going back through the proceedings of what was ultimately permitted as part of the plan use development, I don't seem to see any language precluding. In fact, the regulations that were in effect at that time could have included, based on the language of the regs, a bookstore being located in that new space. Now we find ourselves having both of those contested PUD hearings behind us here on the request for a modification that seems relatively minor, which is to change the height of the signage for the bookstore and to move the door. And so I'm having trouble seeing how we go back to an issue that seems to have been resolved at the much earlier stages of the two prior PUD hearings.
I would put it this way, Your Honor. a PUD proceeding, and that 2018 case is no exception, is a situation where the zoning commission is asked to balance the zoning flexibility that the applicant wants against the public benefits that are going to be provided by the plan. And my client was strongly supportive of the public benefits because, rightly or wrongly, they thought that this would be additional neighborhood serving retail, not retail that would be devoted primarily and with most of its focus toward the students and alumni and faculty of the university.
But that still,
Go ahead.
that still doesn't answer one of the questions that I think the chief was getting at, which is, are you using the right procedure to do this? Was there any way for you to challenge, the relocation of the bookstore directly? And do you have any, kind of examples of when the commission or this court has, looked at a modification request about one thing, signage and whatever, and found that it necessarily included sort of a broader attack on something else? Does that happen? Do you have examples of it?
Your Honor, I would say that would be very difficult because they have this gotcha thing. The approved uses includes retail, and a bookstore is retail. So if you just look at it from a technically legal perspective, I don't see where we could go with that. But my client's point is that in a public hearing, we could look to see whether or not this was merely a bait and switch activity on the part of George Washington to basically get my client's support for the public benefits that were being offered in an illusory fashion, which really weren't the public benefits that they thought they were supporting.
But counsel, if the PUD had said retail as it does, let's take the bookstore out of this and your challenges to the benefits of the bookstore. And let's say GW planned to put a store that sold rotary phones in this building. I think half of the people in this room don't know what rotary phones are anymore, but nobody uses them anymore, right? I mean, it's probably a pretty useless store, but it's a retail establishment. Could your client come in, could they, and under what process could they come in at that point and say, that's not, nobody wants that, nobody in the neighborhood wants that? I mean, is that, first of all, could they do that under the process that we're under here, the procedural posture, which is a modification request for the sign? And secondly, if not, what would have been the procedure to do that?
I suppose that my client could have filed a petition in protest of the implementation of the PUD on the grounds that it's basically being implemented in a way that is misrepresented in terms of what's in the record. But frankly, Your Honor, I think that would be a difficult process to make, because my clients, being unrepresented by counsel, did not, and basically trusting GW, did not precisely exclude the relocation of campus facilities that are retail in nature from taking over this space. That doesn't change the fact that my clients feel that they have a strong complaint that they have been misled in this process, because at no point, and that in the discussions that led up to the 2018 support by my client to this plan, was there any discussion or possibility of a campus bookstore? And we feel that if we were allowed to have a public hearing about what the public benefits were for this plan and how they're being modified on the basis of this modification, that there is some possibility for an alternative result.
But could you do that with respect to any retail choice that GW makes with respect to this space? I guess that's my question. I mean, I use the rotary phone example as kind of an absurd one, but does your client have the opportunity to say yes, no to every single retail establishment that GW proposes to put into this space?
Absolutely not, Your Honor. Our point is
Mhm.
that we would want to explore whether or not this campus bookstore really is neighborhood serving other than GW serving. Our belief is that we could make a strong presentation that there's virtually no interest in the neighborhood surrounding the store and surrounding the university for retail activity in this bookstore.
But
There's,
I'm sorry,
and
sir. I understand that that you're talking about having a hearing and to figure out whether this, transferring the bookstore here is new and neighborhood defining. But is it possible for it to be decided without a hearing whether the PUD even has those requirements? Isn't that a fairly straightforward textual question that can be answered without a hearing?
if you want to look at it that way and say that it doesn't matter that maybe we were possibly intentionally misled in the process, all you need to do is look at the word retail in the authorized uses, and we lose, no question about it. Because, as I said, my client trusted them that when they said retail, they thought it was going to be genuine neighborhood serving retail. That's the argument that we would make to the commission if we were given the opportunity of a public hearing.
Well, I think this sort of goes to my original question, that I was very concerned in reading the briefing about the view that your clients feel that they were misled, which prompted me to go back and to sort of do some digging through the 2007 and 2018 PUD applications and hearings and prior orders of the commission. And I don't really see that language, new, additional, community-oriented retail. And so if the argument is that there was possibly some misinformation or misleading, as Judge Beckwith just said, it seems that would be pretty clear-cut no from what we can see based on the documents in the record. And then the commission is faced with the question before it now, which is a modification request to change the signage and to relocate a door, which they deem to be a modification of consequence, which is an odd term, as opposed to a modification of significance. Modification of consequence under the regulations does not require a hearing. Modification of significance does. And which is what I understand to be part of your argument, that this was a modification of significance, therefore entitling you to a hearing. But when we look at the regulations, 703.6, examples of modifications of significance include change in proffered public benefits and amenities. I guess I'm asking how you view this as a change in a proffered public benefit or amenity. Don't you have to establish that? And how do you establish it at a hearing if it's not in the prior?
I understand the point, Your Honor. What we are saying is, if all we were talking about were cosmetic changes to the building and the relocation of a doorway, that would not be the kind of change that would necessitate a public hearing. And that's how it was presented to the commission by the Office of Planning. And that is how it is emphasized in this court today by GW. What we are saying is those changes facilitated a use of the property that is not what my client understood was neighborhood serving retail, which was the fundamental basis for their support for the PUD.
Is there also, I understand GW to be representing that this bookstore does have some neighborhood serving amenities, that it's not just solely for the students, because there's a coffee shop and there's open space and there are readings and opportunities to have
What- yes.
community events there.
What you have in the record is not evidence. You have assertions of counsel to that effect, assertions with which my clients strongly disagree that this facility will be in any way, shape, or form neighborhood serving. But we did not get the opportunity in a case of where in a public hearing, this kind of information does not come in through counsel argument. It comes in through the testimony of sworn witnesses subject to cross-examination and our opportunity to make the contrary case. But the commission said that is simply unnecessary. But our point of view is we don't have to prove that we would have changed their mind. We just have to demonstrate that we have relevant information that has a bearing on the legitimacy of this, what we regard as a change in what was approved in 2008.
Does that mean you have to proffer the evidence you had put forward?
I'm sorry, Your Honor.
Does that mean that you would have to proffer what you're going to put forward in order to show that
No.
that those statements in the letter, I guess, about how public, what a great public space this bookstore is going to be, show that was wrong? Like, do you have you have to have a good faith basis and show, you
Our
know,
approach to that is quite simple. When in 2021, when there was a decision by the commission that a change in public benefits that GW wanted to place on this project required a public hearing, my client and others who were concerned about that change in benefit negotiated some adjustments to that benefit and consented to the change. And therefore, the modification, instead of being a modification of significance, became a consented to modification of consequence. Our position is that this case, being the extension of a contested case where the proposed change is contested, is a continuation of a contested case. And therefore, we should be entitled to a hearing under the APA to basically demonstrate that this particular modification to facilitate a change that was not fairly contemplated in the original proceeding, we should have an opportunity to be heard on that. I don't think when we make a claim of the denial of a hearing under the APA, we have any obligation to prove or offer proof in order to get that hearing, any particular evidence. And in fact, in this particular case, this change came up so fast, we never had the opportunity to put together the kind of information that we would put forward in that contested case.
But don't you at least have to show, point us to some language in the negotiated PUD that you say that you worked closely with GW in the earlier stages to point to some language that shows that there was some change to what was agreed on? And that's the question that I struggle with here, because I don't see language in the earlier two planned unit development hearings or ultimate agreements orders that shows that this is a deviation from that.
Well, I think what I'm saying, Your Honor, is there's this long list of possibilities in the 2018 order as to what would constitute an approved neighborhood serving use for this property. Retail was among them.
Correct.
That's as far as we went on that at that time.
But how
Because-
could you have gone, I mean, what would have you, excuse me, what would you have done differently at that time beyond saying retail? Would you have said at that time only coffee shops or only, I mean, retail?
No, I think that at that time, in order to legitimize the public benefits that were in exchange for the flexibility, we would have asked the commission, knowing that this was lurking in the background, to say, yes, retail, but not relocation of existing retail that is basically designed to serve the, not the neighborhood, but the university's people itself. I think very easily we could have gotten that into the 2018 decision, because my client at that time was very much in favor of new additional retail. And in fact, when we first opposed this change, we said, well, of course it means new additional retail. But they came back and said, no, the word new is not appended to the word retail, and therefore you lose.
And at the 2018 hearings, public hearings where WECA was able to be present and participate, was there any testimony that what WECA understood was that it would be new and additional retail, or just the discussion of retail?
I think that was my client's, rightly or wrongly, that was my client's assumption throughout that hearing. It may or may not be reflected in the written order. It may not be reflected in the entire hearing. I'd have to go back and look at the entire transcript to make a confident prediction one way or the other on that.
Thank you, counsel. Did you want to reserve? I know we've taken you over your time with our questions, but we'll reserve your time for rebuttal.
Thank you.
Mr. Ronan, I was starting to wonder if I was seeing a twin from the last argument here. So is this public serving new additional community oriented retail in the bookstore?
Well, let me say first, it's good to see you. It's been too long. It actually is, but it's irrelevant.
Okay, I was gonna say it is if everyone in the neighborhood wants to walk around in GW clothing, sweatshirts.
Well, so as was alluded to in the prior questioning, yes, there is GW clothing there, but there are books of regular public interest. There are regular adult books, fiction and the like. There are children's books, college kids are children to me now, but younger than that. There's a Apple support technician desk. There's a made in DC section that people can buy made in DC local products. So this is not a store that's geared just toward the university.
But how do we know that? I mean, and then related to that, I mean, suppose that the bookstore required a GW ID to scan to get in, and then only took GW, whatever payments systems colleges use these days, I don't know. But, and I know you're saying that that's not going to happen, but that's only on say so, right? I mean, couldn't there be evidence that that's actually what you plan to do? And then would that be the type of retail that the PUD envisions?
Well, it's a hypothetical question because that's not contemplated. That's not what's happening. I mean, you can walk in that store today. It's open.
No, I understand, but but there was no evidence of that, right?
Yeah, well, correct. There's no evidence that that's an intention that's ever going to happen. And it wouldn't make a lot of sense from a business perspective either. But I come back to the relevance. I mean, there's a valiant effort in this case by the petitioner to make this case about something that it is not about. This case was our application to change the dimensions of signs, make them a little bit bigger because it's a long name, and eliminate an entrance.
Yeah, but nobody cares about the sign, right? I mean, we know that, right? But suppose the PUD said grocery store. I know it doesn't, but let's say the PUD said grocery store. And then you put in an application for a modification of consequence to say we need to change the sign. We need a bigger sign because instead of giant, the sign is now going to say GW bookstore. All you've done is apply for a modification of consequence to change the sign, when in fact you are altering the PUD. In my hypothetical, I realize that's not this case, but what would WECA do in that situation?
There's a very straightforward answer to that. They can appeal our building permit and they can appeal our certificate of occupancy on the grounds that the use that we're making of the property is not an allowed use. That's what they should have done if they wanted to challenge this issue,
So
but they didn't.
can we go back to what is an allowed use? Is the language new additional community oriented retail in the PUD 1 or PUD 2, I'll call them, related to the development of this area or any of the decisions?
The answer is no, it's in neither as a condition. The allowed uses is, as you pointed out earlier, under the first PUD were retail. And at that point for this space, and at that time, the zoning definition of retail specifically included bookstore. In the second PUD, it's actually was expanded. The allowed uses for this location were expanded to include a bunch of other things in addition to retail. But retail now is defined under the current regulations to be a use where that is engaging primarily in the on-site sale of goods, wares, or merchandise directly to the consumer, which is exactly what's happening here. But your question about this new neighborhood serving language, there is a finding of fact, not a condition, but a finding of fact in one of the PUD decisions where the zoning commission says that it contemplates that this allowing retail space here will, and this is the quotation, will permit the applicant to attract neighborhood defining retail opportunities along I Street. So importantly, that's a finding of fact. It's not a condition, and it's not stated as a mandate. It does not say that every retail use that goes into this location shall be neighborhood defining retail, whatever the heck that means.
So is this relocation of the bookstore, does it thwart that language of neighborhood defining retail?
It does not at all, and I'll explain why. This court, there was actually an appeal of the first stage PUD. This court handled that case and talked about in its decision that the purpose of this PUD, part of the reason it was a good thing, is it creates opportunities for retail and other uses that serve both the university community and the broader neighborhood. And that's exactly what this bookstore does. These are the things I was saying before, that there are products and services sold here that are of interest to members of the public, not just the university.
Is that an expansion of what the bookstore was offering in its old prior location?
I don't know the answer to that.
And so I guess what I hear that is a little concerning, and I can't seem to pin it down yet in the record here, is this notion that WECA was pretty cooperative throughout the process of the PUDs hearings, 2007 to 2018. They had some concerns. You all worked it out. There was full hearing on both of them. And yet they're still left with this notion that there was sort of a hide the ball effort here, that whether all along or just at the last minute, GW decided to relocate the bookstore, which in their mind was never, ever contemplated when we're talking about retail, neighborhood serving, the ability to attract new businesses. I guess, what is your response to that? That this, I won't say negotiation, but this effort involving all of the same parties has been ongoing for some time. And so for one party, despite the opportunities previously to be heard, to still feel like they were given the short end of the stick, that they were not treated with candor by the developers here. When is this the only retail so far that's been located in this space? Is a bookstore that was already in existence, which really helps GW because it gets to expand the footprint of the bookstore, sell more things to its students, and maybe also bring in one or two people from the neighborhood. I'm exaggerating, but I can see how the WECA could have some bad feelings about that. Wait a minute, we went through all of this only to get the bookstore that you already had and bigger in a main commercial retail corridor?
Mhm. I'm glad you asked this question because I want to address this very explicitly. There was no misleading. There was no bait and switch. As you've observed, there's nothing, there's not a shred of evidence in the record or that exists as far as I know that would support a notion that there was any misleading. The reality is that when the first stage PUD and second stage PUD orders were entered in 2007 and 2018, nobody at George Washington University or BXP thought that the bookstore was going here. That the idea of putting the bookstore here came years later after BXP looked for a long time to try to find another suitable retail tenant and was unsuccessful in that. So it ended up being the bookstore, not because there was some long plan where people were hiding in behind the shadows to move the bookstore here. It's the way it worked out, and it's entirely consistent with the allowed uses under the PUD. It simply is not true that anybody at the university or BXP said anything to WECA promising that there were going to be this was only going to be new neighborhood serving retail. It's just not true.
Do you think there was no basis for their expectation at all? They were just like not
Yes, well,
thinking clearly.
you heard Mr. Brown say, well, whether it was reasonable or not, or things to that effect. I mean, I can't dispute that they actually have that understanding. I don't know what's in their heads, but they didn't reasonably have that understanding. And in fact, if you look in the decision in this case, the zoning commission talks about this is exactly the kind of retail we had in mind. I mean, at the end of the day, the zoning commission is the arbiter of what the terms and conditions of this PUD should be. And they say in their decision and then in the discussion, this is the kind of retail we had in mind because it serves both the university and the general public, and it provides opportunities to bring them together for book signings, speeches, events, and things of that nature.
So just from a process perspective, earlier you said there are recourse avenues if the PUD said grocery and you started to move in a bookstore. Are those the same avenues, or are there any avenues if the PUD says retail and you start to move in a shoe store and WECA says, we've got 6 shoe stores in a 2-block radius, we don't want another shoe store here. Do they have any recourse at that point? Is it the same one you identified earlier?
Yeah, I think so. In that circumstance, I think they could petition the zoning commission to reopen the PUD hearing to look at changing the allowed uses. That would be a voluntary thing. It's nothing that the zoning commission is obligated to do. In fact, the law provides, this is the Fournier case, I think is how you pronounce the name, that the zoning commission is not duty bound to reopen proceedings that are already closed and to reconsider issues that are resolved. I mean, again, just to come back, and I appreciate, the hypothetical questions and your desire to think about this more broadly, but this application was just to make a sign bigger and to remove a doorway. And WECA does not have a right, or WECA does not have a right to come in and say, we demand that it be something else, that we get a hearing on the use issue when we did not request any change to the use in our application, and the zoning commission did not make any change to the allowed uses in its order here. So they don't have a right to make this application or this proceeding something that it's not.
I mean, I guess, sorry, we had a moment of silence there, but I mean, if you were planning on moving in the bookstore and the sign was no bigger than the space that was already allotted, then would we be here at all? I mean, you wouldn't have applied for a modification of consequence at that point.
If we kept the entrance way as well.
Right.
Yes, that's right. We would have just gone in for a building permit and then gotten a certificate of occupancy. And as I said, those were their opportunities. If they want to argue that the use that we're making is not an allowed use under the PUD, those are their opportunities to challenge those things. And they had another opportunity, by the way, if they wanted to make an argument that, well, the earlier PUD decisions where they talk about retail really should have had more constraints on them, but they could have appealed those decisions, right? But they chose not to. So, and this is why we talk about in our brief, it should not be the law that they can wait until years later to come in and say, oh, the zoning commission should have put more guardrails around what type of retail are allowed here. They had an opportunity to appeal on that basis and they didn't.
So does that, I think Judge Schenker may have asked this question earlier, but does that mean that GW could put any kind of retail in there? Anything? They could have put a vape shop, a smoke shop, in that space, and the neighborhood, Wicca would not be able to challenge that?
Well, from a zoning perspective, in terms of what the PUD allows, they can put anything that qualifies as retail under the definition in the zoning bylaw, right? They, of course, would have to comply with whatever other regulations or laws apply to a vape shop or whatever it's going to be.
Can I ask one last question? I mean, last for me anyway. I think you argued that when making a modification request like the one you made, you're not required to submit like affidavits and declarations or anything like that. But I wonder, the fact that you're not required to do it always doesn't necessarily mean you're never required to do it. And are there situations where truly as a fact, there are facts that matter in it? I don't know how, how this kind of litigation works, but is there ever a situation where affidavits would be appropriate?
I think the answer to that is probably, it would certainly be appropriate in certain circumstances for the zoning commission to ask for them if they think there's a disputed fact and they want some input on it. I don't think that was necessary here because, again, all we're talking about is making the sign a little bit bigger and removing an entrance. And the materials that were submitted showed what the sign was going to look like. There are diagrams that show what the sign dimensions are going to be. And the zoning commission, of course, has the plans for the building and can see where the entrance is not going to be. So there's no dispute of fact about what's proposed, what's going to happen and what the commission is approving. And that's why there was no need for, an affidavit saying, yes, I promise this is how the sign, the dimensions of the sign are going to be.
So, but as to the attorney's, promise basically about what the bookstore is going to have to offer the community, where did that come up? That's in a letter, is that right?
Yes, that's right. And I think it may have been discussed or mentioned in the on the record too. Well, I guess maybe it wasn't. I'm not sure about that. But yes, it was in a letter. But again, I come back to completely irrelevant. There's no change of use requested. There's no change of use made. The only thing this order did is allow us to modify the plan to eliminate an entrance and to make the signs a little bit bigger. That's it. This court's analysis should begin and end there. And all you have to do is say, the regulations provide that a modification of consequence can be allowed without holding a hearing in the interest of efficiency. That's expressly what the regulation says. A modification of consequence is defined and includes examples that the examples include a redesign of architectural elements. That's exactly what this is. End of case.
Now the regulations also permit the zoning commission, if it deems appropriate, to consider that a request for a modification of consequence is actually a modification of significance and therefore would warrant a hearing. And the commission did not do so in this case.
That's correct. That's correct. I mean, you don't, if you're the applicant, you don't get to say, I demand this is a modification of consequence, even though you're asking for a change in public benefits or something like that.
But is it your position then that if a hearing had been granted or given, or just in the first instance made, that it would be irrelevant to get into the things that WICA is complaining about here?
Yes, if the hearing was to go to the use issue and whether this was an allowed use, I think it would be irrelevant to the application.
Well, if the commission deemed that this was more than a modification of consequence and granted a hearing on the grounds that it was a modification of significance, then in examining whether or not it was a modification of significance, they would look at the proffered benefits. And then wouldn't that get us into the issue here?
I think the answer to that is,
There's a lot of ifs in that
Yeah.
question.
right. Hypotheticals are hard for me, so bear with me. I think the answer is to come back to what the application was. We asked for a change in the plans to reconfigure a sign, make it a little bit bigger and remove an entrance. So that's all we were asking for. Now, it's hard for me to see how that could be considered a modification of significance. But the other thing I would say is this: if the zoning commission wanted to, for some reason, hold a hearing, it would have. I don't think there's anything that would have prohibited it from doing so, but it's not required to do that to address the relief that we were asking for.
Right, but I guess I think the question, and I think I asked this a long time ago, is if you were trying to make what was supposed to be a grocery store into a bookstore, but you strategically did that through a an application for a modification of consequence and said, we just want to change the sign.
Mhm.
Then what, I mean, I guess the question was, what would the board's responsibility be at that point?
Yeah, well, I think that would be a core strategy, because it doesn't work. So if we just came in and said, we want to change the sign, it's going to say grocery, XYZ grocery store, which is not retail, to just make an example. It might be that we get the modification for the sign, right? The zoning commission allows that, but that does not mean we have a right to make the use that's not allowed under the pre-existing PUD. So when we went to apply for a building permit, what should happen is the zoning department, or the building department should say, no, you can't have a building permit for that use because it's not an allowed use. And there could be litigation about that issue. But that's the way it gets resolved. So there is, and this is an important point, it's not that we're not at all arguing there's no mechanism or avenue for them to make this challenge if they want to. They just don't make it on this application, which is limited to minor architectural changes. They have to bring it as a challenge to a building permit or a certificate of occupancy.
Right. Thank you.
Thank you.
All right, Mr. Brown.
I just want to go back to square one for a moment, and the basic legal argument that we were making in this case is that this is a continuation of a contested case. And in a contested case, when a matter is contested, you're entitled to a public hearing. Neither one of us has been able to offer you controlling authority on whether or not when a modification to an approved contested case is or is not itself a contested case requiring a hearing. But our answer to that question is quite simple, and it's controlled by what happened in this case back in 2021. What the commission initially thought was a contested case didn't have to be a contested case because there was nothing to contest. Everybody agreed with the change. In this case, the contested case should be deemed continued because there is a contest. And of course, in that continuation of the contested case, the only relevant issues are ones that are relevant to the modification request. And we have explained that the modification request is relevant to their desire to implement a change that my client says was not within the contemplation of the parties at the time. Now, you've heard from counsel that representations that, oh, we were never even thinking about this way back in the day in 2007 or 2018. He may be right, but we don't have evidence of that. We only have counsel argument. It's exactly the kind of question that we would have brought up in the public hearing to which we were denied. And maybe at the end of that public hearing, the commission will say that this is irrelevant and we see no reason to change or restrict what we approved in 2018, and the modification dealing with the cosmetic changes is fine. But we just want an opportunity to have a chance to see the sworn testimony of the GW people that are suddenly putting out this plan that we had never seen before, and to cross-examine them and to present our own testimony with regard to what was going on back in 2018 when my client supported the change in plans, thinking that this would be new additional retail for the community. So all we're asking for is a fair chance to be to be treated like the long-term cooperative partner that we were for many, many years, which suddenly has turned into a sort of a gotcha thing where my clients feel more like they are, I don't know, rubes in a carnival show that have been basically told that, sorry, you should have brought this up years ago. I mean, I heard counsel say, we're not allowed to lie and wait, and needed to bring something up in a more timely fashion. Well, I'm telling you right now that this was entirely new to my clients in 2023 when the modification request came up. That's why we're here, not because we have a problem with signs or doorways. We just think that this was not a use that should have been thought of as supporting the public benefits package that was presented and led to the commission's approval of the PUD. Thank you very much.
Thank you, counsel, for both of your arguments and briefs and the matters taken under advisement. That concludes our cases for today. Thank you.
All right.